Well, Lords, I'm going to deal with my submissions under 7 headings, not each having the same weight. First of all, the issues in the original claim. Secondly...
Can you do you mind just
of course,
giving me a chance to be in a position to give you my undivided attention? Right. 7 parts.
7 parts. So first, issues in the original claim. Secondly, how the case was put in the fraud claim. Thirdly, how the current point arose before Mr. Justice Leech. Fourthly, the authorities.
So what was the third one?
How the current point arose before...
How the current what?
The current point, the issue that is now the subject of the appeal.
You mean the approach? The approach to be adopted.
Exactly. How that arose before the fraud trial judge, Mr. Justice Leech.
Yeah.
Fourthly, the authorities. Fifthly, issues on workability. So there are rival contentions on the workability of the rival approaches. Sixthly, the judge's approach in theory. And lastly, the judge's approach in practice. Now, that deals with the 7 points on ground 1, and then I will deal with grounds 2 and 3. So first of all, the issues in the original claim. I'm not going to labour this, but I'd ask you to look at the pleadings briefly in the original claim, that is the claim against Mr. Tinkler. Could I ask you to look at the respondent supplemental bundle?
I don't know if I've got a respondent supplemental bundle. I thought we only had one supplemental bundle and some unagreed bundles.
Well, it's the respondent's unagreed, maybe the one that's, I don't quite know how it's been marked.
Unagreed supplementary bundle.
It has 8 documents only in it.
Okay, no, I haven't got that one. Unagreed supplemental bundle are respondent's inclusions.
That sounds like it, yes. So at page 2 of that, we see the particulars of the claim. If I could ask you to turn to...
Okay, I'm
You've got the wrong document.
struggling with finding.
We've got a spare hard.
It's because you said there's only got 8 documents in it. I think that's what.
Have we got like this?
Ah, wait a minute. It's probably this one. Yep. Got it.
So page 2 is simply the front page. Page 5, you see the heading, the defendant's conduct. And of course, at this stage, Mr. Tinkler was the defendant. Under subheading B, the defendant's pursuit of the objective. So Esken's case at this stage was as follows, that from at least November 2017,
So which paragraph of this reading?
paragraph 19.
I thought you said page 2.
I started at page 2 and moved to page 5. So paragraph 19, from at least November 2017, the defendant took steps, as particularised below, to secure the objective being a change in the composition of the board of Esken, in part by the replacement of the chairman, that's Mr. Ferguson, with a view to ensuring that Mr. Tinkler's influence over the board was such that his personal interests would be safeguarded, those interests extending to an increase to his remuneration and/or his reappointment as chief executive or executive chairman and/or such other matters as might from time to time arise. Now, following on from that heading, that introduction, which refers to as particularised below, there are then a series of incidents going through from paragraphs 20 through to 32, which take up an initial period of the narrative. And that period runs from November into December, across into January. Paragraph 28, a meeting on the 10th of January. Paragraph 31, Mr. Tinkler meeting with key shareholders. And 32, a meeting on the 7th of February between Messrs. Ferguson, Tinkler, Brady and Hodges. So that was the initial part of Esken's narrative in relation to the claim against Mr. Tinkler. It then moves on to events leading up to the AGM, which was actually held on the 6th of July. Now, then we get to the defence, and the relevant part is at page 20. Mr. Tinkler pleads events in relation to the four directors' conduct, they being Ferguson, Brady, Coombs and Wood. And his case was that from approximately January 2018, those four took a series of steps, particularised below, to secure the removal of Mr. Tinkler from the board and to shore up their own positions with the company, in particular to perpetuate Mr. Ferguson's control of the board and the management of the company. And they were doing so not for proper purposes or in the genuine pursuit of the interest of the company. And just over the page, letter A, they sought to remove Mr. Tinkler in order to avoid or suppress reasonable criticism and dissent about the way in which the company was being managed. And then at page 22, it moves on to what is defined as stage 1, which is the attempted removal of Mr. Tinkler as a director by consent or Article 89.5, and that deals with events around the 25th of January and an attempt to use Article 89.5. So in effect, there is a narrative starting from November 17 onwards and a counter-narrative put forward by Mr. Tinkler starting in January 2018 onwards. That gives the background for the way in which His Honour Judge Russon dealt with some of these issues in his judgment. And if I could ask you to look in the authorities bundle, where we find that, it's at tab 14, page 735. This is at the very beginning of section 5, findings, and at the top of the page is the subheading context. And the judge finds this: before turning to the issues formulated by the parties, I need to establish what expectations Mr. Tinkler had encouraged the company to hold by his discussions with the board or members of it in early 2018. And he does that by going through a sequence of events, and we see it in para 578. And that starts with an email which Mr. Tinkler writes on the 29th of September 2017. And he notes at paragraph 577 that Mr. Ferguson and Mr. Tinkler are at odds as to whether or not in early 18 Mr. Tinkler had given to Mr. Ferguson the clear impression that he was voluntarily on his way out from the company, and that it was a case not of if but when. So that's what the judge is, in the original trial, is addressing. And he goes through in some detail about the events which are material to that. And so, for example, over the page at para 583, in my judgment, the September email, so that's September 17th, can only have encouraged Mr. Ferguson to believe that Mr. Tinkler was on his way out of the company. Over the page again, 588, I prefer the evidence of Mr. Ferguson in relation to the meeting on the 10th of January 2018, and he explains why. And then at 590 to 596, he deals in detail with findings as to the events at the meeting on the 24th of January, what Mr. Tinkler was saying, what Mr. Ferguson was saying, how it was recorded, and so on. At 597, well, at 596, his conclusion on that, on my assessment of the evidence, the account of Mr. Ferguson is again to be preferred, and he explains more about that. And then at 597, he makes findings about the draft RNS. And then at 603, he deals with what he says the next significant meeting between Mr. Ferguson and Mr. Tinkler was the one that took place on the 7th of February, by which time Mr. Tinkler had met with the key shareholders, and the company had discovered that he had been discussing management and strategy issues with them. So, in other words, His Honour Judge Russon at the original trial made detailed findings on the rival narratives as to what was happening in the context of the claim these early months, September 17 through to February 18. And as is clear from his findings, it involved a wide range of evidence, both documentary, going back to an email and the impact of an email in September 17, and a range of witnesses who gave evidence about that, including, for example, a shareholder or a shareholder's nominee, Mr. Jenkins. So that is just part of the factual matrix that led to the conclusions that His Honour Judge Russon found. So I turn then to the second heading. How was the case put in the fraud claim? Now, if we now turn to the core bundle, please, and the particulars of claim in that case, which are at tab 11, page 321. Now, the first thing to note is the progress of particularisation. It starts off
core bundle 321.
Core bundle 321.
Thank you.
So we see in the tram lines the process of particularisation. There's the original particulars of claim. They are amended by consent in June 21. Then they're re-amended pursuant to an order of Mrs. Justice Bacon, 18th of November 21. Further re-amended by consent, 3rd of December, but that leaves disputed issues, and then a final re-amendment pursuant to the order of Mr. Justice Leech on the 26th of January. So that is fairly shortly before trial. So that's the process of particularisation. And then how the case was put. If I could ask you to turn to page 328. This is within the heading background to the 2018 proceedings. And paragraph 11 that my learned friend took you to is this: the majority on the board's ultimately successful campaign in 2018 to secure the removal of Mr. Tinkler as a director of the company and his dismissal as an employee, so far as was understood by Mr. Tinkler in the 2018 proceedings, proceeded as follows. So this part of the particulars sets out what Mr. Tinkler believed and understood to be the position as at the point of the Russon trial. That is the context in which these subparagraphs are set out. Then, at page 334, we turn to the 2018 proceedings. And Mr. Tinkler pleads to the company's case in 2018, but over the page he pleads to his own case in the 2018 proceedings. And at paragraph 13, he says that his case in the 2018 proceedings was, in broad terms, that 13.1, Brady and Ferguson wanted Tinkler off the board so as to preserve their own positions. And then if I jump a little to the last sentence, therefore from at least January 2018 onwards, Ferguson and Brady sought to force that issue first through the draft RNS and then via the February Article 89.5 notice. Again, that is how Mr. Tinkler summarises his case. If we then turn to page 342, following a description of the disclosure process and the Soames tribunal proceedings, Mr. Tinkler,
I'm afraid I didn't get
page 342.
Yeah, thank you.
So following a description of the disclosure process and then the documents discovered through the Soames tribunal claim, we turn to what are called the critical undisclosed documents of paragraph 30. So the ET disclosure, that is the Soames tribunal, the ET disclosure included a number of documents of critical significance and relevance to the issues in the 2018 proceedings, particulars of which are set out below. Now, obviously, I'm not going to go through them all, but if I go through the first, just to give you the structure of the pleading on the documents. So, first of all, the 19th of January text message exchange, discovered through the tribunal claim. Paragraph 30, messages sent in these terms. 32, here's the response. 33, the natural meaning of those messages is as follows. So there's an alleged meaning as to what was being said. And it includes that Mr. Soames' suggestion that the situation could not continue beyond the short term. There's a reference to his ongoing working relationship with Mr. Tinkler at Stobart Capital. Brady had previously expressed frustration. The plan to remove Mr. Tinkler in the medium term was a first step, and to be inferred was to be implemented from the 9th of February, and so on. So that's what is derived from that exchange, the alleged meaning. Paragraph 34, this is why, therefore, that exchange was material. A 19th of January text message exchange was material to the 2018 proceedings because it showed, the message itself showed, 34.1, as Mr. Tinkler had alleged, there was in fact an orchestrated plan by the company to remove him, and that this was not, as the company had asserted, mere paranoia on the part of Mr. Tinkler. But then a similar structure is applied to each of the what are defined as the critical undisclosed documents. We then turn to page 359. We have the heading that the company's failure to disclose those documents was deliberate. And there is a pleading as to why that was, in circumstances where the documents were all relevant, they were responsive to search terms, should have been at least available for manual review, if not searchable. And fourthly, the critical undisclosed documents were highly adverse to the case the company in fact made during the 2018 proceedings, and to the evidence given by Soanes and Brady in particular, and then various other reasons why it must have been deliberate. So, document, meaning, deliberate failure to disclose, materiality, each based on a reading of each specific document. There's a different category of pleading as well, as I know your lordships are aware, and that is that there was not only concealment, but there was perjured evidence. And we get to that at page 383. And it runs thus at paragraph 77. The Soanes ET disclosure, and in particular the critical undisclosed documents, and then we see that by amendment there's reference to other allegedly undisclosed documents which have emerged through amendment, but by reference to each of those documents. So the documents, the new evidence, if I can put it that way, last two lines, show that at the very least Brady, Soanes and Ferguson all gave false evidence, as set out more particularly below. So again, squarely the allegation is the new documents demonstrate that they gave false evidence. And that extends in 77A to Mr. Coombs, although that I think wasn't pursued. Then, how is that structured? You turn the page, you get this is Mr. Brady's false evidence. At 78 to 80, it sets out the evidence that was given before His Honour Judge Russon. At 81, the evidence was false because. Why was it false? As set out above, the certain specific undisclosed documents or allegedly concealed documents, the documents themselves show that Brady and Soanes have been discussing how Tinkler might be removed, and indeed that Mr. Brady had a, quote, medium-term plan, a quote from one of the documents, to remove Mr. Tinkler prior to Tinkler taking action against the company, and so on. And at 82, the evidence in this respect was known by Mr. Brady to be false in circumstances where the fact that it was Mr. Brady's goal to remove Mr. Tinkler and that he had formulated a plan so as to do so cannot have been something about which Mr. Brady can have forgotten. The plan there, referring to the plan at the top of the page identified in one of the undisclosed documents, or new evidence, the medium-term plan. And that evidence was flatly contradicted by the critical undisclosed documents. So all of this, both in terms of the concealment and in terms of the perjured evidence, is pleaded as being derived from the new evidence. This is what this will demonstrate at trial. And that is, in our submission, unsurprising, because it mirrors the proper approach to claims of this nature. Is there new evidence? Was it consciously and deliberately concealed, or does it show perjury? If so, was the fraudulent concealment or perjury material to the decision taken by the original trial judge?
Sorry, could you just give me that again? Is there new evidence? Was it consciously or...
So, is there new evidence? Was it, that is the new evidence,
Yes.
consciously and deliberately concealed? Or does it, that is the new evidence, show perjury? So the two types of fraud. And thirdly, if so, was the fraudulent concealment or perjury material to the decision taken by the original trial judge? So the pleading sets out, in the way that it should, how a claim of this type proceeds.
I think on your third, you must mean, you say, is the fraudulent concealment or the perjury material? Is the what material that was fraudulently concealed?
That's exactly right.
Or the perjured evidence material?
Yes, you're precisely right. So my third heading, so how did the point that is now in dispute before this court, how did it arise? I can best demonstrate this by reference to our closing submissions, and could I ask you to go back to the supplementary bundle, the white bundle that you found, and look in tab 7. This is the section of our written closing before Mr. Justice Leech, dealing with the key legal principles. And we needn't, for present purposes, look at the initial parts, but at page 90, there is the heading Assessing the Evidence. The first two paragraphs aren't relevant for present purposes, but at the top of page 91, we wrote this at paragraph 38. A second and potentially significant issue has arisen under the guise of credibility. Unsurprisingly, Esken maintains its witnesses were credible both in 2018 and before this court, but great care must be taken in considering the scope of evidence said to touch on credibility. A number of concepts must be kept distinct. So on any contested issue of fact, the court will have to assess the probabilities whether the account offered is more likely or not. So was the document suppressed? Was the evidence false? Secondly, there may then be a question of motive. Was it deliberate and dishonest? That will usually be a matter of inference. People rarely write that they're going to mislead a court. Such inferences are to be drawn from the pleaded facts. Thirdly, these questions may be informed by an assessment of credibility. That has two aspects. A finding that a witness has lied on another occasion in the case may inform the question of whether he's lied on the issue under consideration. It may inform the point, it may not. And then secondly, consideration of collateral matters. In any case, evidence of collateral facts must be carefully managed and assessed. They concern matters that are unpleaded, and as to which full disclosure will not have been given. The witness's answers on such matters will be regarded as final. And then we develop, in the circumstance of the present case, the last point raised a number of issues, and that part, I think, is quoted in the judgment. But what this shows is the context in which this question about the scope of revisiting some of the Russell findings arose. And it was under the, as we wrote, under the guise of credibility. It was not Mr. Tinkler's case in opening before Mr. Justice Leech that he was seeking to and was permitted a retrial of certain issues, and in particular some sort of global issue as to whether there was a plan by Brady, Ferguson and Soames to oust Mr. Tinkler. It is not how the case had been opened. And I've revisited my learned friend's opening, and what it does is it mirrors the structure of the pleadings. These are the critical undisclosed documents. This is the new material. This is why we say it has a meaning of a certain type, and therefore why it was dishonestly withheld or perjured.
But he did say, presumably, that the new evidence, fairly read alongside the old evidence, showed that there was a plan when the judge found there wasn't.
No, I don't, that is not how the case was being put. The case was put in line with the pleadings, which was, these documents in themselves show that there was a plan. The new evidence, as is pleaded, shows that there was a plan. Now, in the pleading, at certain points, there is reference to a context of another document, and so forth. That is unsurprising. But it was not that. You, Mr. Justice Leech, have open forum to review all of the evidence. Had that been the position, then this issue would have arisen at the start, not the end. Now, a review of...
Well, can we see his opening?
I question whether I should bring it, and I didn't because it's 150 pages long, but I can certainly get a copy through.
But your point is that this arose at the end,
At the end.
and not at the beginning.
Yeah.
Because at the beginning he was saying new evidence means there was a fraud on the court.
Yeah.
And at the end he was saying, look at everything together.
Exactly.
Right.
And was saying, so I had understood some of the questioning to be questioning along the lines of credibility, that was what was being put. By the point, so this is obviously prior to our having seen the written closing, Mr. Tinkler's written closing. And at that point it was clearer that what my learned friends were trying to do was pull apart what had been found and allow the judge to revisit it. Following exchange.
So you say the written closing said for the first time that the judge should review the whole thing on the basis of all the evidence.
Exactly. That was so the approach became, here are 16 findings of fact we're asking you to make. The first one is was there a plan? And that involved a pulling together of various bits of evidence from both the original trial and the subsequent trial.
And that was debated in closing submissions.
And that is what led to the debate in closing submissions, where this issue was pulled together, which is why when the judge deals with it in the early part of his judgment, he refers to our written closing and then the oral submissions of both myself and my learned friend, because it was clear by that point exactly what was being advanced on behalf of Mr. Tinkler. And that is not, firstly, the vice of this, and I will return to this, but the vice of this, obviously, is that when His Honour Judge Russon makes findings about these early stages, as you've seen, it involves a wide range of evidence, including from witnesses who were not called at the fraud trial, and including evidence which wasn't ever shown to Mr. Justice Leech. So, for example, the context of what Mr. Tinkler was saying in September, or how things, the debate about remuneration that took place in December and exactly how that was developed. You know, that was not fully explored. Issues sort of raised their little points raised their head in the course of the trial, but not the full adumbration of the evidence that had been before His Honour Judge Russon. So, what my learned friend has said to you in the course of his submissions yesterday is, well, the judge had an obligation to decide these issues on the material that had been put before him. But our difficulty with that, quite apart from it being wrong in principle, is that this was a matter of selection. And it wasn't a matter of the parties putting forward all of the evidence on the issue about whether or not there was a plan. Because unsurprisingly, what, for example, the defendants, the company's witness statements did, was follow the pleading. I've been shown this new document. I'm told that it hasn't been disclosed in the original proceedings. This is what I meant when I wrote this. This is why I say it wasn't disclosed. This is why I gave the evidence that I did before His Honour Judge Russon. This is why I believe it to be true. So the witness statements that were in front of Mr. Justice Leech were not addressing the broad issue, was there some sort of plan to oust Mr. Tinkler, germinating in January 2018 onwards. They were dealing with the new evidence. What did it mean? Was it withheld? And was it, if so, was it deliberately withheld? That was the way in which, unsurprisingly, the defendant's evidence was put together. Now, learned friend's contention before this court is that he was entitled to a retrial of the issue of whether or not there was a plan. And in my...
Can I ask you something about that? You said, and I found, for my part, I found it quite logical, that there were three things the pleading asked the judge to do, right? Is there new evidence? Was it consciously and deliberately concealed, or does it show perjury? And if so, was it material? Was the material fraudulently concealed, or the perjured evidence material to the decision taken by the trial judge? And we can argue what material means in a minute.
Yes.
But you seem to have accepted Mr. Wardell's proposition that the judge should decide whether there was a plan at trial.
I don't accept that.
Right. Why not?
Because what I say is that Mr. Justice Leech was there to decide whether or not the new documents, the new evidence, showed that there was a plan. So here's a document. This refers to a plan in the medium term. Mr. Tinkler says that means a plan to get rid of me. Mr. Brady, as it happens on this particular example, says no, it was a plan to keep you within the arms of the company, but perhaps in a wider role, Stobart Capital. It wasn't to get rid of you. That wasn't my intention. So a debate about the meaning of the use of the plan in that document.
But I mean, 221, the judge says, these are the factual issues I'm going to decide.
Yes.
Did you tell him that wasn't the approach he should adopt?
What the judge was doing was looking at that factual question by reference to each of the pleaded allegations. That's the way he plots through his judgment, and that's the way I said he should do it. Namely, to look at the documents, the new documents, to identify what meaning they had, to identify whether that meaning was supportive of the idea that there was a plan, and if so, whether it was disclosed or not, and if that was for deliberate and conscious reasons. That does not involve a complete retrial of the issues about whether or not, by looking at the whole of the evidence in the round, or such evidence as have been put forward in front of the fraud trial judge, that there was a plan. The question is, do the new documents support a thesis that there was a plan? And if so, is that material? So it is a fundamentally different exercise. The judge in our submission gets it right because under the auspices of issue 1, which is was there a plan, he's answering that question by reference to the new material in the way he's invited to do by the particulars of claim put forward by Mr. Tinkler. As I've shown you, in relation to each new document, this document shows that there was a plan, not this document when read in the wider context of other suspicious activity or something like that.
Well, I mean, I see all that, Mr. Leeper, but if you look at paragraph 219 of the judge's judgment, he says that Mr. Wardell asked me to make 16 primary findings of fact in the light of the evidence as it emerged over the course of the trial.
Yes.
Presumably means all the evidence adduced before him. First of which is there was a plan, right? And then there's 89.5 and there's all the other things, and that he'd lied and so on. And you said, as recorded at 220, Mr. Lepper did not submit, either in writing or in his oral closing submissions, that I should not decide those issues, or there was an issue estoppel. And that was a realistic concession. The existence of a premeditated plan was a central plank of Tinkler's case and provided the motive which he attributed to the witnesses for their willingness to give false evidence. It would have been very difficult, if not impossible, for me to decide whether the judgment should be set aside without deciding some of those issues at least. So you encouraged him to decide those issues, and then there's the argument about the approach.
Well, I completely accept that, but what I was saying is, yes, you are not, to the extent that it's being said that this document shows that there was a plan, you are not trammelled by what His Honour Judge Russon said, which is that there wasn't a plan. Couldn't possibly be, because the whole point of the new evidence was that it demonstrated, on Mr. Tinkler's case, that there was a plan. The new evidence did. But what I said is, when you're addressing these issues, you have to adopt a certain approach, and that's what the judge addresses in paragraph 221 by saying, I am going to look at these factual issues, even though there's an overlap with what His Honour Judge Russon found, but I have to do it in a certain way, and I refer back to what I said at paragraph 33, around paragraph 33, as to the approach that I should adopt.
But I mean, you also encouraged him, because I think, to do the exercise he identifies in 221. Did you? That's what you asked him to do.
I didn't say specifically that you should address the issues in the following way. First, the relevant finding of the judge. Secondly, that was the structure that the judge himself came up with. I don't. That's a matter of, if I may say, judgment as to how the judgment was structured. No more than that. So I wasn't saying, well, the first thing you need to do is set out the judge's findings then. So that wasn't something that I created.
But the methodology that's identified in the third step, which is considering whether the new documents or evidence provide cogent evidence of dishonest conduct, was very much.
That is exactly what I was
What
saying.
you say the judge.
And the judge.
You said at the time the judge should be doing,
and he rightly adopted.
He was saying to us,
exactly,
he should have been doing.
And he refers to the adopting that approach that he's already found is the right approach in the earlier section of his judgment.
And can I just be clear? Are you saying that was the right approach because that was the way it was pleaded and addressed at all stages whilst the trial was going on before closing speeches? Or are you saying that that's the right approach because, as a matter of law, limb 1 of the test requires the new evidence to establish the fraud?
Yes, it's the second that is my position. And the reason I refer to the pleadings is because in my submission, the pleading of the case, the particulars of the case, reflect the proper approach to cases of this type. What is the new evidence? And it is the focus upon that and what the new evidence demonstrates. So I'm not simply taking a pleading point that the claimant should be stuck with his pleaded case. I'm saying that the pleaded case properly represents the correct legal approach. It is unsurprising that the pleading is structured in that way because that reflects the proper legal approach.
And just to pursue that for a moment, in deciding whether the new evidence establishes a fraud, does the judge necessarily also have to take account of old evidence on the same issue?
In relation to perjury, inevitably, because one has to look at the evidence that was previously given.
So, just in the context of perjury, when you say the new evidence must establish the fraud, it's not only the new evidence which will be taken into account. So what causative potency does the new evidence have in relation to that question? Must it just contribute to the finding of fraud?
No, in my submission, you demonstrate the perjury when you gave this answer. You demonstrate the perjury through the new evidence. So this new piece of evidence says that you say you had a plan. To the judge, you said you didn't. That was false because this document shows, or this series of new documents show, that you did. Your evidence to the trial judge cannot stand because this new evidence, whether it's 1 or 3 or 5 or 20 documents, when taken together show that you did in fact lie to the judge. So you have to look at what was said to the trial judge because that's obviously in the terms that the Master of the Rolls put it, the false representation to the court. The other type of false representation is that this document didn't exist.
What if you had a case where, in the first decision, the judge had said there are a number of indicia that the witness was lying about this, and it's very finely balanced, but on balance, I think that the documents 1 to 6, which suggest that he was lying, don't carry the day in the light of documents 7 to 10. And then the new evidence involves documents 11 to 15, and the judge has to take into account not only documents 11 to 15, but also documents 1 to 10. Is the judge entitled to say, in the light of documents 11 to 15, they tip the balance back, the second judge, they tip the balance when I take them together with documents 1 to 6?
Well, I think there are two answers to that. Firstly, if documents, I've forgotten the numbers, but 11 to 20, whatever,
Yeah.
If the new documents were all in one direction, to show that there was a plan, that the individual had lied, then actually it would be on the defendant to say, but let's pull in, that can't possibly be right because you have to look at the other evidence, so the claim fails. The new evidence does not establish that. But the other way it could be done is for the claimant could have pleaded that this new evidence shows that this was perjured evidence because it has to be taken into account with certain specific parts of the evidence that was put before the trial judge, certain specific instances. And that happens in the pleading. There are specific other documents which are referred to. This is taken in the context of so-and-so. Learned friend gave you an example.
I'm just questioning your assertion that the new evidence must essentially be the sole cause of the judge deciding that there was perjury, taking perjury as the dishonesty. And in the real world, it may be a contributing cause, it may be a major factor, but it may not be the sole reason that he reaches the decision if he inevitably has to consider some of the old material on the issue in question.
With respect to, I think that's addressing it from slightly the wrong perspective. The question is, does the new evidence, which consistently refers to there being a plan, is that, does that demonstrate that what the individual was saying at trial was wrong? Now, it may be that, as I say, the case could be pleaded to say that this can only be seen by reference to certain specific parts of evidence that had been before the judge. But that isn't what happened here. So it could be the new evidence has to be seen with. That isn't the approach that my learned friend was advocating.
At what stage does the court proceed from considering the new evidence and its materiality to allowing a complete re-trial of the issue before the first judge? You said that the issues 1, 2, 3 and 5 were issues that were before the first judge.
Yes.
And Mr. Wardell was asking the new judge to decide the issues that were before the first judge.
With respect, I don't think he was saying, well, I say that's not the question he should have been asking. I wasn't accepting that there could be a rerunning of certain issues.
No.
My position was there was necessarily an overlap between
I'm not criticising you.
No, I'm not.
I'm just asking you, at what stage properly do you move from considering whether the judgment has been vitiated by fraud to retrying the issues the first judge tried? Because here the judge seems to have started his consideration of whether the judgment was vitiated by fraud by retrying the issues the judge tried. Whereas I would say that the way you put it attractively 15 minutes ago is what he ought to have done.
But I don't accept that that's what you're proposing is what the judge did. The judge didn't go and redecide those issues. What the judge is saying at this point is there is an overlap. What Mr. Leeper is saying to me is that overlap doesn't debar you. There is no estoppel there, inevitably, because just because His Honour Judge Russon didn't find that there was a plan, doesn't mean that I'm somehow, says the judge, debarred from considering whether there was a plan. But I am now going to address that question by reference to the new evidence, and that is precisely what he does, by reference, essentially, to the way in which the case had been pleaded. And I was going
Shouldn't he have answered the first question first, which is, was the judgment vitiated by fraud? And to do that, you ask yourself whether false evidence was given or material was concealed, and whether that was material. to the judgment.
Absolutely. And in my submission, that's precisely what the judge did. He looked at what is the new evidence, does it mean, what was the evidence about what it means.
Where does he answer those questions?
Well, at every point.
Okay, show me, let's take the plan. Where does he answer the question, was the new evidence, was the question as to the plan vitiated by perjured evidence? Is that at the end of the section on?
So if you look at 255 on page 196.
Okay.
So having set out the various bits of the new evidence, he says, I turn therefore to my findings on issue 1. In my judgment, the new documents upon which Mr. Tinkler relied do not demonstrate that by the start of 2018, Mr. Brady had begun to devise a plan to remove or otherwise neutralise them. I say it for the following reasons. So none of the new documents contain clear evidence that there was a plan or how he intended to implement it. It was never put to Mr. Brady that he was considering an alternative method of removing Tinkler before that date, or what method that method might have been.
But I mean, it's a slightly odd way of approaching it. I mean, I would expect him to say, the new evidence does not demonstrate that there was a fraud.
But he goes on to deal with the fraud in the next section, dishonesty.
Isn't the difficulty that the judge has been drawn into a sort of hybrid approach? Because he may have started out and conducted the trial, according to you, by reference to the pleaded case, but the structure of this part of the judgment has taken Mr. Wardell's 16 requested factual findings, which actually isn't the way the case was pleaded. And the trouble is that the judge has, as it were, tried to blend the two together.
I don't wholly accept that. I don't. There would be a different way, which would be of going through each document and doing it in turn. What I think the judge was doing is saying, well, if you look at these documents that have been pleaded, they're the ones that are said to show that there was a plan. So I'm going to deal with those in a section. So if you look...
It would have been perhaps, I think you say, more logical to follow the legal approach that you gave us, for the judge not to address this part of the judgment by reference to Mr. Wardell's 16 requested factual findings.
It wasn't something I was proposing that he do, but I don't suggest that it's wrong. And if I could ask you to look at page 186, this is why. He has the heading, the new evidence. So he deals with...
Sorry, which paragraph?
So 186, you have the heading, the new evidence, towards the top of the page, immediately.
Paragraph 235.
Yeah. And then at 235, you've got the first in time, not in the pleading, but the first chronologically, which is a sensible way in my submission to address it. He deals with the New Year's resolution note. Then at 237, the next in time, the 19th of January text message exchange. The 29th of January note at page 239. 243, the Stobart buyout email and attachment. 244, presentation. 249, 8th of Feb email. 251, 12th of Feb email. So he goes through each of the new bits.
Logical order to ask yourself, rather than the list of questions Mr. Wardell had given him, to ask yourself first, was this evidence fraudulently concealed from the court? And two, Because if not, you don't get to first base. And does it demonstrate that they lied?
I completely accept that, but in my submission, that's
Why
what
wasn't he asking those questions?
but that is exactly what he does ask. He says, what is the new evidence? He sets out, by reference to each of the pleaded bits of new evidence. He then says, what are my findings? My findings are that they don't show what the alleged meaning is. Then he goes on to say, well, was there dishonesty in relation to the fact that these were not disclosed? And having found that there was not dishonesty in relation to each, he then addresses in the alternative question of materiality. So it is exactly the structure.
You had the problem in relation to concealment and perjury in that they were, to some extent, connected.
Yes,
it was being said, if they've lied about there being a plan, it's more likely that they were deliberate in suppressing the documents. And conversely, if they deliberately suppress the documents, it's more likely that they perjured themselves because their motive for doing so was because there was a plan. So he couldn't perhaps divide up concealment and perjury into distinct compartments as separate stages.
With respect, I say that's right. And if you look at, in his judgment, he specifically says, I make it clear that I look across the board when I'm addressing some of these questions. So if I'm having to decide on credibility, I look not at each point, but I also have to take the evidence in the round. That is the evidence given at the trial about the new evidence.
When you were answering my Lord Master Roll's question, you took us to 235. Wouldn't it have been, it's more accurate to take us to 256 and onwards, isn't it? Because isn't that the section in which the judge says, here are all the individual documents, I'm now answering the question, have they been dishonestly concealed or the like? I think, isn't that what Master Rolls was searching for, rather than taking us to the first section, 235?
I was intending you to take you to both, but the structure that the judge adopts is to consider, to make findings of fact as to whether or not the new evidence demonstrates a plan. And part of that is because, as he has set out, and we've just seen the passage, that is said to be a reason for the dishonesty.
Yeah, I mean, I understand my Lord Justice Popplewell's point about the interrelation. We've got a problem because of the loop between concealment and perjury.
So he makes...
But the actual section that, according to your structure, is there new evidence? Well, we all know there's new evidence, and each of the documents is listed out separately. But then the question, was it fraudulently concealed or does it show perjury, is what he addresses in his section C, headed dishonesty.
That is right. That's
and
exactly.
We see paragraphs 258 and following, he makes discrete findings on each document.
Exactly.
He didn't consciously or deliberately choose not to disclose the note. He left it to Mr. Rosenblatt. He didn't consciously disclose the other thing. Didn't deliberately mislead the judge, etc.
So in relation...
But what he's done, in fact, is he's by putting the section headed
new evidence.
Yeah, well, or effectively answering the question, does the new evidence show that there was a plan? In a sense, that's his way of informing himself of that question before answering that's his way to try and break into the circle. He says, I've got to break into this circle somehow. I'll break in by asking, was there a plan, Mr. Wardell's question. But then I address the legal issue, which you say he should have addressed, which is, was there actually a fraud?
Exactly
Was the court
right.
fraudulently?
Exactly.
So
some of these points...
It may be that the structure of these sections could logically, I think, have been put the other way round. He could have said, these documents, I find that these documents are not fraudulently withheld, but in reaching that decision, I need to sense check that against the question of whether there was a plan.
That is right. But one can see the difficulty of going down that route, which is that you start off by saying, well, I'm going to look at this document. Was it dishonestly withheld? Well, this one wasn't, because
Well,
It was reviewed by the solicitor.
but it's because part of the motive for dishonestly concealing is whether there was a plan.
Exactly right.
So that's why he logically addresses that
Exactly
first,
right.
but he doesn't not address the question. That's what you're saying.
That's exactly right, with respect.
So you say that if you look at paragraph 2, I mean, I'm grateful to my lord for this because, and of course, I read this judgment before hearing all this argument.
Indeed.
He goes through 30 paragraphs,
yes.
actually, of saying this was not dishonest, the evidence was not dishonest, this document was not dishonestly concealed. And then he turns to, at that point, to materiality at paragraph, I don't know, 286.
Yes.
But in the previous massive section, he's drawing the threads together of the claim that these things had been dishonestly concealed and that and that there'd been perjured evidence. And my lord says, well, he had to deal with some of the facts. And do you say that actually it doesn't really matter that he put the old evidence that was there to one side, because the question was, does the new evidence show there was a fraud?
Exactly. That's exactly my position. And one can understand why the judge adopts this approach, because...
Sort of.
Well, and I say it precisely for the reasons given.
2 days later you can begin to see, yes.
Yeah, well, yes. It's enormously complicated, and I will take you to the passages where the judge said, this is enormously complicated. I had to struggle to work out the way to do it, and I couldn't find another workable way.
Well, the complicating factor in this case particularly, which I think we did explore with Mr. Wardell as well at some point, is that this isn't a simple case where, that it is said the motive for concealment was the existence of a plan. But you only get to know that there's a plan by looking at the concealed documents, so that there is an inevitable circularity here. And the question is, how do you break into that as a matter of analysis? It's a question of where you break into the...
And if this had been atomised by looking at the document, each document, and then the question, and first the question of dishonesty, there's a risk that there would have been a criticism that the judge hadn't looked at the question in the round to identify whether there might be a motive for the dishonesty. What the judge says by saying in 255, by saying that the documents don't show clear evidence of a plan, that allows him to say, there being no clear evidence of a plan, as it was put to me, there isn't a reason for withholding them. That's part of it. It feeds in by taking that global view as to what the documents showed. So, and that mirrors the pleading.
Sorry to interrupt you, but I just want to bottom out what the judge was doing and whether you support it. Can we look at paragraph 33 and 34? Now, I don't want to put words in your mouth, Mr. Leeper, but I think you would agree with paragraph 33. It was not the judge's job to hear and decide the same issues again with the benefit of new and old material, and that was a danger of real injustice, because the other judge had heard lots of stuff he hadn't heard. Gives an example. But I want to just ask you about 34. Obviously the first paragraph the first sentence is fine, but I'm entitled to assume that the judge decided the issues correctly on the evidence before him in the absence of a successful appeal. The task for me then was to hear and evaluate the new evidence, decide whether Lim 1 was satisfied, and if so, whether the judge could stand in the light of that evidence by applying the test under Lim 2. And then I make it clear, I've set out the evidence I heard, etc. So do you support all that?
I do, and let me just break out. I know Your Lordship said that we knew this by rote, but let me just break it out slightly. He says I'm entitled to assume the judge decided the issues correctly on the evidence before him. Just a part of it that my learned friend repeatedly omits. He doesn't say I'm entitled to assume the judge decided the issues correctly. All he's saying is I'm entitled to assume that the judge decided the issues correctly on the evidence that was before him, there being no appeal. The task for me then, so there's my background. The task for me then was to hear and evaluate the new evidence and decide whether limb 1 is satisfied, dishonesty, exactly right.
You might say as pleaded.
Exactly right. But decide whether limb 1 is satisfied, that is, was there fraud, was there dishonesty, and if so, whether the judgment could stand in the light of that by applying the test under limb 2, materiality.
So you say that's bang on.
Precisely right.
And you say he did it in a rather convoluted way because of the nature of the case.
Because of the complexities of the enormous planks of new evidence.
And his four-stage approach, at stage 2, he's looking at the new evidence in order to decide the issue of essentially perjury. Because, is this right, in relation to the allegations of perjury, the real issue was whether false evidence had been given. If it had been, it was pretty obvious it was dishonest. It wasn't a two-stage approach. Whereas when it came to concealment, which is what he deals with under the heading of dishonesty at stage 3, it's really the reverse. The conduct wasn't an issue. The documents weren't disclosed. It's a question of the mental state by which that non-disclosure came about. So that although he doesn't address dishonesty as such in stage 2, it is necessarily part of his thinking in deciding whether, before you get to dishonesty, was there false evidence given? Was there a plan?
Yes.
And that's what he's addressing by reference to the new evidence in the second of his 4 stages.
Yes.
Is that right?
Yes. And also, as had been pleaded, what the true meaning of the document was. So when it refers to a plan, let me understand and remind myself of what the evidence was about whether or not, when Mr. Brady refers to a plan in the medium term, what was the evidence about that? Was it that, yes, it was a plan to oust him, or was it a plan to manoeuvre him but within the bosom of the company? So he reminds himself of the evidence to give himself the context for the findings which he's being invited to make, because the pleading says the reference to plan must mean a plan to oust. So the judge has to scrutinise the new material to understand what it is actually saying.
I mean, at the risk of stating the obvious, limbs 1, 2 and 3 are actually in the wrong order. I mean, I think it's reasonably obvious. I think certainly you'd say that it should be limb 3, limb 1, limb 2.
Yes, I've never been clear about
why limb 3 is where it is. I mean,
exactly.
So you first of all, and in fact, this is the way the judge does approach it.
Yes.
He says he puts his secondly in paragraph 221 is to identify the new documents. The question is, that's limb 3 of the test, as defined at paragraph 11. In other words, are there new documents? Which is a fairly easy thing to answer. He then considers limb 1, which is in fact is limb 1, namely, was there dishonest conduct? and then he addresses materiality, which is limb 2 of the test.
Yes.
And why? And you is this right? You say it wasn't wrong of him to start off with a preliminary identification of the relevant finding of the judge because he needed to break into the circle somewhere.
Yes, that's what this is all about. You know, this is all about, well, what's the context for what is being said. So this is where it arises in the treatment of the case by His Honour Judge Russell. So there I've found my foothold. I'm not saying that that's right to the extent that it is being said there's new evidence. I'm just recording it. There's my platform. Now I have to look at the new evidence which is said to touch upon those findings and then consider the dishonesty in relation to it.
But in fact, what he does at his second stage, which is B, it's not just identify the new documents, but to address the question as to whether the new documents demonstrate perjury, essentially.
Yes. And that's why later on when you get...
So he's actually considering limb 1 of the test in relation to perjury at section B, at least in relation to this issue, I think probably throughout. And when he gets on to what he foreshadows as his third stage, considering limb 1 of the test, in fact he's only doing that in relation to the concealment allegations under the rubric of dishonesty.
And
right?
that is because the perjury, so was there knowingly false evidence, for example, is identified as a separate issue. So when he comes to deal with
That's
those...
not quite the case, actually, because if you look through those 35 paragraphs that my lord told me to look at more carefully, you see that he does deal with both concealment and perjury. So he, I mean, I haven't got an example for you, but if you can see at
So 265 is an example on page 201.
Yeah, exactly. 265. I find that he didn't deliberately mislead the judge about that message. I think AT being sorted as well was, in fact, an old document, if you remember.
That is my recollection.
So he dealt with perjury alongside the thing. I mean, it could be said, unkindly perhaps, that the problem was created by the list of findings put forward to him.
Well, yes. There was, in fact, a list of issues which had been put together and agreed, which you won't be surprised to learn mirrored pleadings.
But the list of issues never gets mentioned by the
No.
judge. Have we got it?
I've got access to it.
I'd like to see
Yes,
it,
we'll
please.
that.
I think it would help to see what, at the beginning of the case, the parties thought it was about. No, not now.
No, I'm simply.
Junior is taking an assiduous note.
I've no doubt.
He's already
have
got
it
the
here.
opening submissions, and I see how thick they are, but it won't make any difference to me because electronically it doesn't really matter.
Okay.
You only got to your third of 7 points.
We have, it's fair to say, delved into some of the others. Can I just make one further point in relation, before I move on to the authorities, which I would like to touch on. And it's this, again, it's not a pleading point, but it reflects on the way in which the case developed. As you've seen, there was a process of amendment and re-amendment. And in the course of that, Mr. Tinkler was given permission in the face of our opposition that he should have done this earlier or whatever. He was given permission to amend on some issues, but he was refused permission to amend on others. So One example of that is in relation to the date of the creation of Mr. Brady's note of the 7th of February meeting. You may remember that the judge refers to that in by way of background at paragraphs 106 to 110. And
Do you want us together?
no, it's at page 130 at paragraph 108. So Mr. Brady kept a detailed note of the meeting in which he recorded that Mr. Tinkler was considering an executive chairman role, used the expression to brief shareholders against the board and the company to describe Mr. Tinkler's conduct. He also recorded Mr. Tinkler as acknowledging that his actions were not acceptable. At the trial, Mr. Tinkler challenged the accuracy of Brady's note of the meeting because the metadata showed that it was prepared on a later date. On the 19th of February, Mr. Brady sent the note to Mr. Ferguson saying it would be a good file note. Despite Mr. Tinkler's challenge, the judge, obviously, as Honour Judge Russin, accepted that Mr. Brady's note was accurate. See 179 of the Russin judgment. He also accepted that at the meeting, Mr. Tinkler recognised that his actions had been unacceptable. See paragraph 736 of the Russin judgment. And what Mr. Tinkler sought to do is to plead this in the fraud claim. And Mrs. Justice Bacon considered that application, and she refused permission to amend it. And essentially her reasons, for your note really only, it's at pages 70 to 71 of the respondent's supplemental judgment. She recorded that it was a matter traversed in detail in the 2018 trial, so it wasn't really new. The evidence had long been available. On the basis of that evidence, the point should have been pleaded at the very least in March or April this year, 21, rather than waiting until now to seek to amend. I therefore do not permit that amendment. So there was a refusal of permission on the allegation that Mr. Brady had essentially fraudulently claimed that a note had been produced the day after a meeting when in fact it had been done.
And that amendment would have come at paragraph 78-ish under those particulars of false evidence given by Mr. Brady.
I don't recall. I imagine that would be its place. And Mrs. Justice Bacon refuses that amendment. Now, on Malone and Friends' case, that would nevertheless still be open for scrutiny by Mr. Justice Leech because it was just part of the evidence, that the entire panoply of evidence that was relevant to consider whether or not there was a plan, because essentially Mr. Brady was making up a note to back up his position, which was not accurate. That means that you're left in a situation, well, what's the purpose of the pleading in this type of a claim if you can rehash any old point, whether or not it's been pleaded?
Well, what it goes to, in fact, is probably where you're about to head, which is in the direction of the authorities. What's the actual structure of the test that we've been looking at, the LIM 1, 2, 3, or the formulation that you gave us?
Yeah.
What is the proper legal basis for this type of jurisdiction to set aside a judgment for fraud?
Yeah. And it is
and
not.
There was a debate with Mr. Wardle to some extent yesterday about what's the juridical underpinning of this jurisdiction. And the point you've just alighted on, I think, is really foreshadowing that, isn't it?
That's exactly it, and that was the purpose of it, to be frank. That's exactly right. That is exactly right.
I mean, the problem is the way this has all been set up, with the plan being centre stage. The one thing the one place you don't break into my Lord's circle is by retrying an issue on the assumption that there has been fraud and materiality and everything else. You don't break into the circle there, and the judge makes it look as if you do, which is what I suspect gave Mr. Wardell airspeed earlier. The question, which is difficult, I think, is if you break into the circle by showing there was a fraud, if you satisfy whatever the correct test is for materiality, at what stage and in what circumstances do you start to retry the issues the judge decided? Because Mr. Wardell would say, on day one, when I stand up and say there was a plan, and you said there wasn't a plan, it's the judge's job to retry those issues on all the evidence.
But what the claimant should be standing up and saying is, I've got new evidence through which I will demonstrate that there was a plan. And that evidence, which is new, was deliberately concealed from the court.
Yes, and that shows that the judgment cannot stand.
Exactly.
But then what happens is that is not that there is a finding of all the issues that were before the first court, but that there is a retrial of the case before Judge Russell.
Exactly, and you're slightly ahead of me. But if what Malone, inevitably, but if what Malone and Friends says is right about the process that the judge adopts, which is that you have a retrial on the whole question of
it all happens in one.
I'm sorry.
It all happens in one.
It all happens in one. So what's left for the retrial of the original claim? Because there's been a determination that there's a plan. I'll come back to that.
And it merges the materiality questions and the question of
exactly that.
What is vitiated.
May I turn to the authorities, and perhaps we could start with the Amphill Peerage, which is at tab 17.
You're not going to show us Flower and Lloyd?
Well, I hadn't put it in the bundle. I think it's sufficiently referred to in here.
If I'd had time overnight, I would have read it, but I didn't. Could it be provided?
Yes, of course.
Just save me finding it. I'd also like to see Lord Buckmaster's case.
I think it's to the Jones Code.
Genesco
Genesco.
and the Privy Council case. There are two judgments from Lord Buckmaster.
The Amphill Peerage case.
Yes, so this is obviously slightly unusual in that it's before the Committee for Privileges. There are reasoned judgments from Lords Wilberforce and Simon. Lord Kilbrandon agrees with those. There are separate reasons from Lord Russell, which I don't think touch on the legal principles in issue. And the remaining, I suspect, non-legal members of the committee agree, page 936. Just a couple of passages. First of all, at page 903, we have looked at...
Is this a case that's binding on anybody?
Well, I can't see that it is, if it's a set of opinions produced for the Committee for Privileges, but obviously of persuasive force and has been adopted.
I mean, I've never seen a case like this reported in recent times.
There was one, actually, when I was a pupil in relation to a Monaghan, I think it was Monaghan peerage, that now Mrs. Justice Lang was involved in. But I'm not sure it was reported, but it was a similar sort of hearing to determine these sorts of issues. So page 903. what Lord Wilberforce says, say 4, the second line, that this principle of finality of determination in the matter of legitimacy is, of course, but one strand in a more general fabric. English law, and it's safe to say all comparable legal systems, place high in the category of essential principles that which requires that limits be placed upon the right of citizens to open or to reopen disputes. But at letter D, goes on to say this: for a policy of closure to be compatible with justice, it must be attended with safeguards. So the law allows appeals. The law exceptionally allows appeals out of time. The law still more exceptionally allows judgments to be attacked on the ground of fraud, and limitation periods may be extended. But these are exceptions to a general rule of high public importance. And as all the cases show, they're reserved for rare and limited cases where the facts justifying them can be strictly proved. Now, he develops that at 905. At just for letter B, learned counsel for John Russell, without venturing upon a definition, suggested that some kind of equitable fraud or lack of frankness was all that is meant, but I cannot accept so anemic an ingredient. In relation to judgments, in this case is surely a fortiori, or at least analogous, it is clear that only fraud in a strict legal sense will do. There must be conscious and deliberate dishonesty, and the declaration must be obtained by it. Authorities as to judgments make clear that anyone wishing to attack a judgment on grounds of fraud must make his allegation with full particularity, must, when he states it, to be prepared to prove what he alleges, and ultimately must strictly prove it. The establishment of the fraud is a condition precedent to reopening the case. See Jones, Co. and Beard. Nothing less can be expected in the present case. And Lord Simon deals with this in a slightly more detailed way at page 925. So just for letter B, to impeach a judgment on the ground of fraud, it must be proved that the court was deceived into giving the impugned judgment by means of a false case known to be false, or not believed to be true, or made recklessly without any knowledge on the subject. No doubt suppression of the truth may sometimes amount to suggestion of the false, but short of this, lack of frankness or an ulterior or oblique or indirect motive is insufficient. Moreover, Jones Co., a decision of your Lordship's House, confirmed that to impugn a judgment on the ground of fraud, the fraud must be alleged with particularity and proved distinctly. The person is not permitted merely to allege fraud in the hope of discovering it as the case develops. Then a quote from Lord Justice James in Flower and Lloyd, approved in Jones Co., and a further quotation from the Master of the Rolls in Flower and Lloyd: the fraud used in obtaining the decree being the principal point in issue and necessary to be established by proof before the propriety of the decree can be investigated. The impugner of a judgment as obtained by fraud must adduce evidence of fact discovered since the judgment, which show a reasonable probability, which I take to mean a prima facie case, of such fraud as would invalidate the judgment. And that I read as saying you've got to have a prima facie case for it to be allowed to proceed, not that that's the ultimate test. But what it does show is that you've got to adduce evidence of new facts.
Well, and that the evidence of facts discovered since the judgment must show such a fraud.
Yes, exactly right.
So
yes.
there has to be a causative link between the new evidence and the fraud.
Absolutely. And just for your note, this point about particularisation and the reference to Jones Co. was quoted with approval by Lord Kerr in Takar, paragraph 47, page 828. Can I then go to the next in time, what I say is relevant case of Hunter, which is at tab 5, 1982.
Sorry, what was the passage at 591F in Amptil Peerage cited with approval by Lord Kerr?
No, I don't believe so. But I'll have to check. So if I turn then to Hunter at tab 5, the only reasoned judgment was given by Lord Diplock. And if I could ask you to look at page 143. So there's obviously so tab 5, page 143. There's obviously a reference to the reasonable diligence point, which was overruled in Takar. But Lord Diplock continues by reference to what was said in the Court of Appeal. Lord Justice Gough also examines the two suggested tests as to the character of fresh evidence. So this is letter C, which would justify departing from the general policy of finality, by permitting the claimant to challenge a previous final decision against him by a court of competent jurisdiction, and he adopts as the proper test that as laid down by the Lord Chancellor in phosphate sewage, namely that the new evidence must be such as entirely changes the aspect of the case. So again, the emphasis is that it is on the new evidence. That's perhaps stronger than the Ladden-Marshall test, and then between D and E, the new paragraph. The latter test, however, is applicable where the proper course to upset the decision of a court of first instance is being taken, that is to say, by appealing to a court with jurisdiction to hear appeals from the first instance court, and whose procedure, like that of the Court of Appeal Civil Division, is by way of a rehearing. I agree with Lord Justice Gough that in the case of a collateral attack in a court of coordinate jurisdiction, the more rigorous test laid down by Earl Cairns is appropriate. So essentially, there are two routes. You can either go to the Court of Appeal, you can ask for new evidence to be admitted, Ladden-Marshall, and that test applies. But if you're going to proceed by what perhaps not then, but certainly by now is established as the more correct route, which is to bring a freestanding claim of fraud, it is being brought to a court of coordinate jurisdiction, and that requires the more rigorous test to be applied, entirely changing the aspect of the case.
So has this ever been overruled?
In my submission,
was it ratio?
In my submission, it is the ratio, and the first part was overruled, and the second part has not been.
So the dicta of the Court of Appeal to the effect that a less rigorous test is appropriate, you say is contrary to House of Lords authority?
Yes. My learned friend's position is that essentially Hunter was overruled, and I say, well, the reasonable diligence was considered in Takar, but not this.
Can you help me with this? This is looking at the materiality question by reference to the effect of the fresh evidence, which is also, I think, how it's adopted in the Highland case by Lord Justice Aikens. But if you're right that the new evidence plays a part, indeed an important part, in Lim 1, that is to say, whether there was fraud, whether there was conscious and dishonest conduct, how then do you apply the materiality test, which is dealing with causative potency of the fraud on the judgment, the first judgment? How do you apply that by reference to the fresh evidence rather than the fraud itself? ought one not logically to say limb 1 has a fraud been established? Limb 2, 3, whichever way you put it, materiality, has the fraud had the material effect, whatever the test may be, on obtaining the judgment, rather than has the fresh evidence done so?
No, because because there are two limbs, separate limbs, which are trying to protect the finality of the earlier judgment. And it is not only that there was a fraud, so fraud doesn't simply unravel all, it is a fraud that withheld evidence that was material, that would have been or could have been, depending on which is material to the outcome. So it has got to have a causative effect on the outcome. It is not enough just to say, well, there is some fraud. Obviously, in cases of perjury, that may be a harder distinction to draw, because if someone has perjured themselves, then, as Mr. Justice Leech recognises, that is a more complicated case to try and work out what the honest evidence would have been, and can you really disaggregate the honesty of the witness from what the true evidence would have been. In relation to, the position is easier in relation to a concealed document, because then you can say, well, yes, it was deliberately withheld, but it wouldn't have factored into the reasoning of the judge in any sense. So the fact that it was deliberately and dishonestly withheld isn't enough to set aside the judgment. It's got to have been causative in the sense of material to the outcome of the judgment. So in relation to the document, you've got to see how the withheld document might have fed into.
I can see one can apply the test fairly straightforwardly.
Much easier.
In the case of a concealed document. But how does it work for perjury?
Well, you can, obviously there are going to be extreme cases where the fraud trial judge will say, this must have had a material impact. There is no other way of reaching a conclusion on this. But they could equally say, well, what they were dishonestly covering up was for purposes which were wholly unrelated to this case. They shouldn't have done it, but had they given the honest evidence, it wouldn't materially have impacted on the case. There can be different reasons of deliberately giving false evidence. But the falsity has got to emerge through the underlying new evidence.
So does it come to this, that if you're right that at limb 1 it's necessary to show that the new evidence establishes perjury, then when you get to the materiality question, there isn't really any distinction between the fraud, the perjury, and the new evidence itself in terms of looking at what the effect was on the first judgment.
Yes, I think, an example from this case might be, why was Mr. Tinkler dismissed? Was it, and the judge finds it's because he sends the original judge finds that it because he sends a letter in certain terms at a certain point, and that is the causative thing. That is why he is dismissed. And in fact, whether or not there's a proceeding plan, it is neither here nor there to that outcome, because they would have done it in any event. So there's a distinction that can be drawn in the reasoning there. So the perjury might not have any material effect on the outcome of that part of the case.
Thank you.
I mean, obviously you can think of all sorts of examples, but the sort of document or evidence that somebody might either conceal or give falsely for reasons unconnected to the outcome of the trial might be the sort of material that, you know, is personal material or goes to credibility.
Yes.
Somebody denies a sort of particular behaviour or conceals documents that are relevant to that might show particular activities which are unconnected to the actual issues in the case, but might have been said to be relevant to credibility. And the judge might say, well,
or masking it for reasons because they reveal a completely separate form of criminality, or they reveal some other illicit conduct that the individual doesn't want to reveal. So that is the reason for it was dishonestly withheld, but there was a reason for it, and had something been honestly admitted, it wouldn't have had any material impact on the outcome. But one other point, and I made it, but perhaps didn't make it clear enough, is that the perjured evidence must be established through the new evidence. So the perjury is established through the new evidence. Not just, you can't just rehash and say, well, I think that you were lying under oath. You have to base it on the new evidence, which shows that there was the perjury.
I understand that, and that's why I was putting to you that I thought you were saying that if you've got through that stage, then there isn't really any distinction between whether the fresh evidence is material or the perjury is material, because you're not really drawing a distinction between the two.
Well, I think you do then have to revisit what would have happened if the fresh evidence had been given. But then there may be extreme cases where the perjury is of a type where the judge say that undermines everything.
Can I just pick up your formulation of the test? It picks up something that you were asked maybe about an hour ago, I think. Is it that the new evidence shows that there was perjury or so I think you said that the new evidence has to show that there was dishonesty, or has to show that there was, in this case, perjury. We're talking about perjury. Does it have to just tend to show, in the sense that you possibly can't overcome that hurdle unless all the evidence points in one direction and is reviewed in isolation from the other evidence?
Well,
how do well, you had an exchange earlier, and I think it was with Lord Justice Popplewell about, or maybe it was with Master Rolls, about documents 1 to 20. And I don't want to get into that sort of again, but what's the actual test? That the new evidence must itself show perjury, or that it must
Can I ask you
to show?
Can I ask you to look at a different authority on that, which is Chodiev, which is tab 2. So this is a judgment of Mr. Justice Burton from 2015, and at I just lost it. Page 37, he starts dealing with the law. And if you look at paragraph 19 on page 39, he at this point is looking at the reasonable diligence point. So we can scrap, to the extent there's reference to reasonable diligence, we can scrap that. But he refers here to a judgment of Mr. Justice David Steele in KAC 2003, and he enunciates his theory as follows: a judgment obtained by perjury is a judgment obtained by fraud. The action seeking an order setting aside the earlier judgment must be based on new evidence which was not before the court that heard the first action. And then we delete the rest of that paragraph. The new evidence must establish perjury in the sense that a person or persons sworn as a witness in the earlier action who could properly be treated as the successful party itself willfully made a statement in those proceedings which statement the person knew to be false or did not believe to be true. burden is on the claimants to establish perjury is distinctly more probable than not. The disparity between the perjured evidence and the new evidence would be material if it entirely changed the nature of the case. So certainly what Mr. Justice David Steele is saying in that case is the new evidence must establish the perjury. And that is one of the barriers, the hurdles to bringing this sort of a case, which is there to protect the finality of judgments.
But he's recorded as having got his principles from Hunter and Mr. Justice Langley in Sphere Drake,
yes,
and Spencer Bauer. And there's nothing, is there, in Hunter or Mr. Justice Langley and Sphere Drake on this question of the link between the new evidence and the perjury?
Not in Hunter. I don't think there is in Sphere Drake. But I'll come to that in a
Sorry,
moment.
in Hunter, I thought there was. I thought we were just looking at it. In Lord Simon, in Lord Diplock. I thought he said the new evidence must be such as entirely changes the...
Yes, that I think my Lord Justice Popplewell was asking a slightly different question, which was about the connection between the new evidence and the perjury.
At Lim 1.
Yes.
Lim 1, yeah. Yep, sorry.
Thank you.
Can I deal at this point with a submission that the learned friends made on Hawthorne and Hollington? And they have referred for this to the case of Rogers and Hoyle, which is at tab 11. I should have said Hawthorne. I think that's my autocorrect in my note. Hawthorne and Hollington. So at page 413, Lord Justice Christopher Clark says this: the reasoning that survived is that set out in the following passage of Lord Goddard's judgment in the Hollington case. It frequently happens that a bystander has a complete and full view of an accident. It's beyond question that, while he may inform the court of everything that he saw, he may not express any opinion on whether either or both of the parties were negligent. The reason commonly assigned is that this is the precise question the court has to decide. But in truth, it's because his opinion is not relevant. Any fact he can prove is relevant, but his opinion is not. The well-recognised exception in the case of scientific or expert witnesses depends on considerations which for present purposes are immaterial. So on the trial of the issue in the civil court, the opinion of the criminal court is equally irrelevant. Nothing surprising in any of that. And then paragraph 39. As the judge rightly recognised, the foundation on which the rule must now rest is that findings of fact made by another's decision maker are not to be admitted in a subsequent trial, because the decision at that trial is to be made by the judge appointed to hear it, the trial judge, and not another. The trial judge must decide the case for himself on the evidence that he receives and in light of the submissions on that evidence made to him. To admit evidence of the findings of fact of another person, however distinguished and however thorough and competent his examination of the issues may have been, risks the decision being made, at least in part, on evidence other than that which the trial judge has heard, and in reliance on the opinion of someone who's neither the relevant decision maker nor an expert in any relevant discipline, of which decision making is not one. The opinion of someone who's not the trial judge is therefore, as a matter of law, irrelevant and not one to which you ought to have regard. Now, learned friends say that principle shows that Mr. Justice Leech had free rein to consider anything that had been put before, even though it had been considered and ruled upon by His Honour Judge Russon. Now, I don't doubt the principle in Hawthorne. It started off as relating to opinion evidence, to the determination of a court in a different jurisdiction. It's commonly applied to prevent findings being admitted in a case where the parties are different, so that there can be no issue estoppel, but nonetheless the earlier judgment of a different court can't be admitted. But that's quite different from the present case. It's the same parties, and as was emphasised by Lord Diplock in the Hunter case, it's a court of coordinate jurisdiction, and it is hearing precisely a case about whether or not an earlier judgment had been obtained by fraud. Inherent within that is a regard to the findings of the court of coordinate jurisdiction. They stand unless and until the fraud is established, as I'll come on to demonstrate.
Well, if it was taken logically to its end, to its
Well,
sort of final conclusion, it would undermine the entire res judicata doctrine, wouldn't it? I mean, if you said that no second judge could ever take into account the opinion expressed by a first judge, I mean,
it's just not dealing with this type of situation at all. Can I take you just to a quotation in the judgment of Mr. Justice Leech from the case of Owens and Bracco. That's in the core bundle at page 99.
Which paragraph?
I'm so sorry, paragraph 24. So Lord Bridge made a point in Owens and Bracco, which he considered still stands. The rule rests on the principle that there must be finality in litigation, which would be defeated if it were open to the unsuccessful party in one action to bring a second action to relitigate the issue determined against him simply on the ground that the opposing party had obtained judgment in the first action by perjured evidence. Your Lordships were taken in the course of argument through the many authorities in which the salutary English rule has been developed and applied, and which demonstrates the stringency of the criterion which the fresh evidence must satisfy if it is to be admissible to impeach a judgment on the ground of fraud. So that demonstrates in my submission two features. Firstly, that it is a focus on the fresh evidence, and secondly, that it's the fresh evidence which is relevant in considering whether there was perjured evidence. So again, it's that point about the interrelationship between the fresh evidence and the perjury, because if one was simply able to say, well, that witness lied, then that would reopen far too much. Then may I turn back to you?
I'm not quite following that submission. What is the rule that Lord Bridge was referring to in the first paragraph of the quote?
Well, my submission was that it's important to recognise the tension between the public policy interest that a judgment procured by fraud should not be allowed to stand, and the public policy interest in the finality of judgments. So my recollection is that the rule is that you must have fresh evidence. The rule rests on the principle that there must be finality in litigation. And it must demonstrate the stringency of the criterion which the fresh evidence must satisfy if it is to be admissible to impeach a judgment on the ground of fraud.
in a sense, you get that from the Amatil Peerage case, don't you?
Well, you do.
From the expert
I'm trying to add a weight, and perhaps inappropriately. Can we then move back in the authorities bundle to the Sphere Drake case, that of Mr. Justice Langley, 1999, it's tab 13. So at page 581, Mr. Justice Langley opens on the law in relation to judgments obtained by fraud and sets out three core principles. There's no doubt that in law a judgment obtained by fraud is liable to be set aside, and that a judgment obtained by perjury is a judgment obtained by fraud for the purposes of that principle. Secondly, there is also no doubt that the courts have been concerned to ensure that the circumstances in which claims to set aside judgments on this ground can be made are defined and restricted to secure the obvious public policy interest in the finality and sanctity of judgments between the same parties. Thirdly, over the page, in this case there is no dispute that to succeed in an action on this basis, the plaintiff must adduce fresh evidence, meaning evidence which was not before the court or courts which tried the first action, and then we delete the rest of that sentence. There are, as I've said, disputes as to whether or not in law, and if so, the perjured evidence must be attributable to the party which was successful in the first action. The attribution issue, and we have Odyssey, and that was dealt with by Mr. Justice Leech and isn't in dispute. And as to the quality and degree to which the fresh evidence must be material to the issues and the impugned decision, the materiality question, which he goes on to deal with later in the judgment. At page 589, he turns to the materiality issue. And he sets out the different submissions, the rival submissions on the one hand of Mr. Grabner and the other side of Mr. Sumption. And then at 590, he refers to some practical factors. So number 2, for example, there is a difference in principle between a test of materiality which looks only to the materiality of the evidence to the impugned decision, and one which looks to its materiality to the final result in the sense of what the decision might be if the matter were retried with honest evidence. I think this distinction is not reflected in the language of many of the authorities, but in my judgment, the relevant test must look to the impugned judgment, which it is alleged.
I'm not where you. I'm not.
Bottom of page 590.
Oh, thank you. Relevant test. Yes, I got it.
In my last 2 lines, in my judgment, the relevant test must look to the impugned judgment, which it is alleged was obtained by fraud. Moreover, if a case arose in which the court could readily determine that, despite some perjury, the outcome would not have changed, I see no reason why it should not, and every reason why it should so decide on ordinary principles of causation. So, at least in a theoretical sense, there can be perjury, but it is not material, and therefore the judgment stands.
So you're saying if this is analogized to a claim in deceit, the deceit has to have had a causative effect.
A causative effect, whatever the test is for that.
Yeah, so if you deceive somebody, but in fact it doesn't change,
Makes no difference at all.
the transaction or the outcome.
Exactly right. Just at the bottom of the page, he says this: I've not set out these factors to demonstrate that I'm faced with a difficult task, but simply to demonstrate that this jurisdiction is one which, unless it is kept within strict limits, is capable of over-analysis and indeed overuse. The existence of this jurisdiction will be self-defeating unless it is limited to circumstances in which it can be plainly demonstrated that the successful party has dishonestly obtained the fruits of victory. He sets out his views on materiality, which we've already looked at. So at 598. But in the course of that, he sets out some of the policy reasons which underpin that. So at the bottom of 598, the paragraph there, in my judgment, the judgments and tests in Hunter's case are to be preferred, and in particular, as expressed in the word of Lord Keynes, that the fresh evidence must be such as entirely changes the aspect of the case. Those words require that the court must form the impression that the fresh evidence would have entirely changed the way in which the first court approached and came to its decision. Not only is Hunter's case recent and high authority and authority directly in point, but in establishing a slightly stricter test, it gives preference to the justice of the finality of judgments between the same parties. Insofar as the principles on which a judgment may be set aside for fraud require re-examination or re-expression, in my judgment they should be more, not less restrictive of the circumstances in which such a course is permissible. It's one thing to apply them to a short case which turns on the credibility of two witnesses or the authenticity of a single document, which of course is the Takar case. It is quite another to apply them to a case such as this, and especially so where the judgment sought to be impugned to now many years in the past and the events to which they relate began in the 50s. The prospect of a yet further trial is unattractive in the extreme. Courts do make mistakes, including mistakes in accepting evidence which is unreliable. The trial system is designed to minimise that risk. The appeal system exists to the same end. There is nothing illogical or unjust in limiting the circumstances in which a resulting final judgment can be impugned by one of the parties to cases where fresh evidence demonstrates that a party has dishonestly set out to deceive and in effect succeeded in deceiving the court. I was going to come back to Takar, but could I just, in similar vein, take you to one passage you may well have in mind in Lord Sumption's judgment. So this is page 834 in tab 15.
Takar.
Takar, yes. So paragraph 67. I recognise the risk of frivolous or extravagant litigation to set aside judgments on the ground of fraud, but like other members of the court, I think that the stringent conditions set down by Lord Justice Aikins in Highland, combined with the professional duties of counsel, are enough to keep it within acceptable limits. I do not think that the imposition of further conditions would be consistent with the long-standing policy of equity of reversing transactions procured by fraud, so approving the principles in Highland and finding that they are stringent conditions, and that is consistent with ensuring that there is not frivolous or extravagant litigation to set aside judgments on the ground of fraud. My learned friend places quite substantial weight on an observation made by Lord Sumption in paragraph 60 on page 831, that an action to set aside an earlier judgment for fraud is not a procedural application, but a cause of action. Well, that's very far from being in dispute. In fact, I rely upon it completely. What does it mean? What does at least Lord Sumption mean by it? Well, he says that there are two aspects. Firstly, it is a claim that can be brought of right rather than an application requiring permission. Secondly, it is as a separate cause of action. In paragraph 61, he says this, it relates to the conduct of the earlier proceedings and not to the underlying dispute. Therefore, there's no question of estoppel and so forth. As we've seen, though, this is a type of claim that requires careful particularisation by reference to the elements, the new evidence, the fraud, materiality. And the trial on this cause of action is on that pleaded case, And as with any other case of fraud, it is properly confined to the pleaded case and not to the underlying dispute.
Just something. I mean, equity has always exercised a special jurisdiction to reverse transactions procured by fraud. What is the quote equitable cause of action that he's talking about? I mean, I'm not aware of what it is. I understand the common law cause of action called deceit. I'm not entirely sure what equitable cause of action in fraud. I've just never come across it before.
No, that may be deeper in the learning of Lord Sumption than I've been able to penetrate. But I think my Lord, the Master of the Rolls yesterday, was referring. What I suspect it is that it's the equitable remedy that follows on. Exactly.
It's the equitable remedy of rescission he must be talking about. There's nothing else. I mean, we don't summon up equitable causes of action out of nowhere that none of us has ever heard of in this court.
No.
No.
So
I mean, I'd always understood you couldn't just say,
oh, well,
this
there
was a
we
fraud.
are. No, exactly.
There is no cause of action in fraud
exactly.
as such.
Exactly. So I assume that the Master of the Rolls has hit on the answer to that.
But it does. But it is interesting, I think, because the cause of action in deceit, as I said yesterday, requires a representation, proof of falsity, and reliance. And it is quite hard to see what the reliance is. Obviously, it's the materiality bit, but it's quite hard to see how this learning that we've looked at ties in with the cause of action. Now, we're not going back to Maitland and saying that the forms of action can't succeed unless you can show a form of action. But it is actually there is a distance between the language of some of these authorities and the actual cause of action. And I mean, I completely see the tension between the two principles of finality of litigation and the equitable right to set aside causes of action attained by fraud. But if you were more disciplined and looked at it as a common law cause of action, which I think it is, you might have to stretch the conditions. I mean, that's which I personally think is the most interesting part of this case in a funny way. But it may not be anything we have to decide.
I wouldn't encourage a decision on that myself.
Well, except that it does have a bearing on the main point that Mr. Wardell has argued, because he's put himself fairly and squarely on the basis that the judge ought to have decided the question before the first judge on all the evidence. And if the cause of action is one in fraud, then the focus ought not to be on what the first judge decided on all the evidence, but on the representation that was made, whether it was made fraudulently or the conduct relied upon, and whether it was fraudulent conduct, and what its effect was on the decision.
But I think the reason that this has emerged is because there is this tension between the competing public policies of there being a fraud, and so if there's a fraud, you can have an open speculation as to whether there was a fraud and what impact it had. But that in this case, there is a public policy of the finality of litigation, which means that you can't just come along and say a fraud was perpetrated on the court.
No, it has to be material.
Because there has to be the new evidence. And that's why it is out with, or it is a peculiar form of that type of action, because there is a delimitation on the nature of the circumstances in which you can advance the case. And it can't be on what was originally there. Whether or not there was a fraud on the court, whether or not there was a perjury is not enough.
But that's
just the court's got it wrong, and that happened.
But legally, anyway, I would have said intellectually, that all goes into materiality. Because you can envisage a fraud on the court. You know, somebody gives evidence, doesn't want to reveal a criminal record and lies about something quite peripheral to the case in order to deceive the judge into thinking something that was wrong. But it had absolutely no bearing on the decision in the case, and that is decided under the heading of materiality.
But that, with respect, doesn't address the question of whether or not there's new evidence. The need for new evidence is the protective barrier that ensures that
no, but the new evidence
challenge
would be,
to the original claim.
The new evidence would be the witness said he had no criminal record, but he did. Here's the evidence of the criminal record. I mean, it's a stupid example because it's useful in one sense because it explains that the new evidence must have a bearing on the issues the judge was deciding before you can even sensibly allege that it constituted a fraud.
Yes,
on the court.
But I don't disagree. But the essence of the cause of action is that it must depend upon new evidence.
I mean, I don't think anybody. Well, that's not actually right. It depends on. I mean, the language actually includes some other rather strange in Highland. It's new evidence, conduct, deceit. I can't remember, but it also includes some kind of conduct.
It's not any old new evidence. You can't just say, I've got some new evidence, give me a retrial on certain issues. It has to be, here is some new evidence which was deceitfully kept from the court or presented to the first court, isn't it? I mean, that's
Absolutely.
I mean, that's the core of this jurisdiction. I mean, that is necessary but not sufficient
Exactly
to get you
right.
into this jurisdiction.
Absolutely. That's exactly right.
Yeah.
And the language in Highland is of it's reference to evidence given, action taken, statement made, or matter concealed. Just in my submission, trying to encompass the various stages that there might be in litigation. You can make a false statement. You can give perjured evidence. You can withhold withhold evidence by concealing it. It's just different ways of the fraud being conducted in the course of the trial. Then you get the questions: is there new evidence? Was there the fraud in relation to it, and was it material?
I mean, the difficult question. I mean, if you're right about Hunter, it's decided. But the difficult question that really brings into play the tension between the finality of judgments and the cause of action to set aside a judgment on the grounds of fraud is what needs to be the effect on the judgment. Does it need just to be shown that the judgment might be different, and that's counterintuitive in one way? I know we're going to look at my predecessor's judgment in a minute, but and my own, well, not my own, but the judgment which I signed up to. But that's counterintuitive because if it's not quite a stringent test, then the finality of judgments might be impugned.
Well, that's exactly right, and we'll come on to materiality, but it is another stringent test to ensure that there is finality. Stringent. It is expressly put forward in Hunter by Mr. Justice Langley and so forth. It is said we need that stringent test at the level of materiality because we have got this battle of the competing public policies. We don't want there to be frauds, but equally, finality of litigation is of great public importance. Where that leaves the line being drawn, well, I say it isn't a matter for your lordships, but in any event, I say it doesn't matter in the facts of this case, in the reasons of this case. But I'll.
You say the judge was wrong to. I can't remember what he said. Did he say he preferred the Highland test?
He said he preferred Highland. He said that.
But I'm going to apply both.
In any event, no, he said in any event, I don't think they're any different, which is precisely the submission that learned friends had put forward themselves before the trial judge. And then he says, but I'm going to apply both.
But you say they are different.
I say I don't need to persuade you of either. I do say, if I have to go there, I say that Highland is the right test and Takar makes that clear. But I don't have
Takar and Hunter.
Takar and Hunter.
Hunter's more important than Takar, because Takar, it wasn't ratio.
Hunter is dealing exactly on the point. Takar...
Well, it was an overturn.
Yes, absolutely. But it is reinforcing in Takar, as Lord Sumption is explicit, these are stringent tests. There's no doubt in their mind that they've reviewed the Highland principles and they have said these are stringent tests and that is necessary because of the finality of litigation.
You're going to go to Hunter, but there's some unsatisfactory bits in Hunter.
There are, of course.
Well, I mean, not of course.
Can I come on to materiality when I get to ground two? It's my fault because reviewing the authorities on what I say is relevant to establish the principles for the cause of action has made me go into that area.
But it is. I mean, they're so interrelated that it's very unhelpful, I think, to look at authorities on materiality separate from authorities on deceit and new evidence.
That's why I've tried to pull them together, but I will come back.
So we've gone to Takar, but we haven't gone to Highland.
Well, we haven't gone to Highland simply because Takar says this is right. It's a paragraph in Highland, and as my learned friend says, it's a paragraph which begins there's no dispute between counsel. But I should say, it says there's no dispute between counsel, but it is done by reference, as I know my Lord Justice Popplewell has identified, it's done by reference to footnotes. So it's not just, well, counsel submitted these are the agreed principles. They are footnoted principles, and the judge gives in each case, for each of the propositions, gives the underlying authority. And the authorities are, I mean, he refers to the Amphill Peerage case, footnote 98, the Tuvyuhu case, which we actually put before Mr. Justice Leech. It was a decision Mr. Justice Law was unreported. Spear Drake, which I've taken you to. And also...
Sorry, I missed the beginning of the sentence.
These are the footnoted cases which
in Takar.
In Highland. Let me show you, rather than letting you...
I wonder if we could be provided with Mr. Justice Law's case. I think it's Tuvahu.
Yeah, we can certainly do that. It was before Mr. Justice Leech.
Yeah. I mean, just looking at this side, I find some difficulty with the formulation in Highland, but you're not going to go to the case.
No, I'll take you there now to show you what I was saying. If you look at, it's at page 341 of the authorities bundle in tab 10. So it's paragraph 106, and you'll see that there are numbers which are in the same size script as the rest of the text, but they are actually footnotes. So you have footnotes 98 to 101. Those footnote references are at page 370. So 98 is the Amphill Peerage case.
So which page are you on?
I was on page 341.
Okay. Oh, I see. And then we see these big numbers.
Exactly.
And where are the footnotes?
That's at page 370.
They're endnotes.
They are endnotes. You're quite right.
Oh, I see. And we've got to be who.
Exactly. So there's
My lord got
98,
the pronunciation right. But
98.
I think it's to the Yahoo, in fact. I think there's a typo.
Right.
I did
that case, the Law's case, Spear Drake, and then Q8 Airways Corp, the KAC case. Mr. Justice David Steele.
I mean, did the the House of Lords say nothing about perjury in the Kuwait Airways case? I mean, I'm just asking because I was involved in that litigation for many years, and I didn't do the perjury litigation.
I recall that you were.
But what I can't remember is, I think I'd just gone on, I can't remember when it all happened, but anyway, I didn't do it. But I recall that the perjury allegations were decided by the House of Lords. But I may be wrong, it may be a misrecollection.
So, I have the...
Could somebody check?
I have the judgment of Mr. Justice David Steele, which is in the bundle.
No, I get that, but I know that was the retrial, I think. But look, I'm just
Absolutely.
asking whether I'm forgetting something.
We can check on that. So, I mean, all I was taking you time because you mentioned it, but it's at those are the paragraph 106 is the paragraph with its endnotes, and that is what was approved.
Yeah, but what about the formulation? Because it does go to some of the questions my lord was asking you earlier.
It has within it an assumption about new evidence, so it doesn't, perhaps surprisingly, given the jurisdiction that is being exercised or the cause of action that's involved, it has an assumption within it, in my submission, that we are talking about new evidence, as all of the other cases deal with.
I mean, just to identify the issues, the principles are, first, there has to be a conscious and deliberate dishonesty, nobody disputes that, in relation to the relevant evidence given, or action taken. What does that mean? Statement made or matter concealed, which is relevant to the judgment impugned. So, the conscious and deliberate dishonesty, relevant evidence given, that's perjured evidence, action taken, not quite sure, statement made.
Kidnap the witness, perhaps.
Yeah, bribing the witness.
Kidnap the witness.
Bribing
You can't
the
give
witness.
evidence.
Just bribing the witness.
Bribing the witness.
Bribing the witness, okay. Right. Which is relevant to the
Kidnapping the
judgment.
commercial court, but we just bribe them in chancery.
Second, it must be material.
So what you have is, under the first principle, you have a reference to the relevant evidence given, action taken, statement made, or matter concealed. In the third, what is made clear there is that the question of materiality of the fresh evidence. So that is where you get to the fresh evidence. Now, I think in an ideal world, it would be slightly reformulated so that it put the principles in a slightly clearer way, and I've already articulated how I would put them. I don't disagree.
You
with
say
this.
it omits in limb 1 what ought to be there, namely that it's the fresh evidence which demonstrates
Exactly. It refers to the
conscious and
relevant
deliberate
evidence.
dishonesty.
Exactly. It refers to the relevant evidence, and then in 3 it says
And that's not there.
it's not there. But what that must mean, one can infer from the third principle, because it does explicitly refer to the materiality of the fresh evidence.
Well, can I put something else to you, which is what I find confusing about it. The words relevant evidence given are the evidence given at the first trial. Right?
Yes.
In the second principle, the words the relevant evidence I suppose means the same thing. But in a sense, it's the point my lord was putting to you about the difference as to whether it's new evidence that must be material, or whether it's the fraud that must be material that is proved under issue 1.
Yeah, but the second says that the relevant evidence or concealment. So let's put it as perjury or concealment of documents. It must be material. And material means that the fresh evidence that's adduced after the first judgment has been given is such that it demonstrates that the previous concealment or perjury was an operative cause of the court's decision. So
Yes,
it
but
shows
it doesn't
you've got,
show where you bring in the fresh evidence.
well, it shows that you've got to prove the relevant action, the perjury or the concealment, through the fresh evidence.
You see, the problem is that I mean, it's all very well saying it's not very well formulated because it's now adopted by everybody in the universe, but it does say there has to be conscious and deliberate dishonesty in relation to the evidence given when it was the perjured evidence at the first trial.
But that's
It
right.
doesn't say
That's right.
where you bring the new evidence in proving your case.
But that is it is established in the second that the fresh evidence that is adduced after the first judgment has been given is such that it demonstrates.
Yeah, but you've got to materiality by that time.
Well,
Okay, I mean, I mean, you say we don't need to decide any of that. We just do what we're told.
well, exactly. Well, no. You uphold the trial judge's approach, and if I can turn to that,
I mean, it's possible that you can conceal evidence from the first trial judge and cause him to reach a decision without anybody actually perjuring themselves. It's just that if that evidence had not been dishonestly concealed, it would have cast a different light on the judge's fact.
oh, absolutely, that's absolutely.
So, I mean, what I think Lord Justice Aikens is trying to do, as I see it, is just try, in his composite formulation, is trying to imagine the sort of things that commonly go on that could be regarded as deception.
But if you conceal
fraudulent interference with the first decision-making process.
You could
And
conceal.
the problem is because he's tried to produce an all-encompassing formulation.
It's a portmanteau approach, isn't it?
Yeah.
Exactly. Can I turn to what I'd said was my fifth heading, which is the rival of questions on workability. What are the implications of what learned friend contends for? Well, the full extent of those became clear only yesterday afternoon.
Sorry, I'm afraid I'm behind. Are you on your fifth point?
Fifth point, workability.
Workability.
Workability. So, is what my learned friend suggests workable, and he criticises our approach as unworkable. What my learned friend accepted yesterday was that the approach is this: you try all of the issues again, you compare the outcome that you reach with that of the first judge. If it's different, you work out why. Is it because of the new documents? And if so, were those fraudulently withheld? But that was...
I think the only thing because I think that certainly came for a series of questions
It was. Yeah.
I think he said it's not all the issues, it's all the relevant issues.
Yeah.
And then the question is, how do you define what's relevant? Mr. Wardell very definitely kicked back when I put to him, that means you just have a complete retrial. He said, no, you don't. You just try the relevant issues again, and then there is a question mark over how do you define that.
Yeah,
so
I didn't mean to suggest that he was
but it'd
saying...
be quite useful if you could,
Yeah.
certainly for me, address that question.
Yeah. Well, First of all, there's absolutely no authority justifying that that is the right approach. And taking it as an approach, if you look at, so Learned Friend says that the relevant issues are just the whole schema of, or the whole case theory of, was there a plan? That means that you would have the first trial judge, the original trial judge, finding that there was not a plan on the evidence in front of him. The second trial, the fraud trial judge, possibly concluding that there was a plan. Then the fraud trial judge might say, well, I've reached that view, but actually it's nothing to do with the new evidence. Or, I've reached that view on the new evidence, but the documents weren't deliberately concealed. So the fraud claim fails. And then you have two judgments of two different judges of coordinate jurisdiction, one of whom has considered, both of whom have considered this issue separately.
On different evidence?
On the second, on additional evidence.
No, different evidence, because in this case, much of the evidence before the first judge was not rehearsed before the second.
That's a very fair point. So on different evidence. So additional, but
got the same point
lesser.
Considered on different evidence by two different judges of coordinate jurisdiction.
And the first judgment stands because it has not been shown that there was a fraud or that the fraud was causative. But you do have completely separate findings. And that is something which is surprising if that were to be the approach that were to be adopted. You would then have an individual who was subject to adverse findings on one judgment saying, well, that wasn't justified because I've got a second judgment. And the judge says, well, there wasn't a fraud on it, but let's look at the findings of the second judgment.
Presented in questions for res judicata and issue estoppel.
Yeah, absolutely. And just practical issues. I mean, if you've got someone who's looking perhaps to clear their name because they want to go to a regulator and say, I haven't done anything wrong, look at judgment 2, and the regulator's going to say, but isn't there judgment 1? And isn't judgment 1 still binding? And the individual says, so I mean, it produces impossible legal but also practical questions. And the individual who's found themselves to be in a better outcome on the second judgment would be saying, but in that there was new evidence that wasn't before the first trial judge. And the loser in the second case would be saying, yes, but you didn't have the full panoply of evidence. It's an impossible situation for the court to allow, which is why I say the only proper approach is that the second trial focuses on what is the new evidence. Was there a fraud involved, and was it material? Because that way, by focusing only on the narrower issue of the new evidence, it avoids the undermining of the first trial's judgment, unless there is proved to be an operative fraud, in which case you go to a retrial and you start again and you get your definitive judgment then. This is the approach that my learned friend advances is completely contrary to the policy of finality of judgment. And as I speculated earlier, there's an alternative route, which is that the second trial judge reaches findings based on the new evidence and whatever other evidence has been put before him, and finds that there was a fraud, that the original judgment needs to be set aside, but has reached a conclusion that in this instance there was a plan. How does that impact upon the first trial judge? So it's not just that what my learned friend says is that the fraud judge has to reach conclusions on whether there was a plan, and then work out whether it was impacted by the new evidence and whether there was fraud on it. But you have a finding based on the evidence of the fraud trial. You have a finding on whether there was a plan. Then the matter is remitted, because it's successful overall, for a retrial in front of either the original judge or a third judge. What is the status of the findings in the fraud trial? That there was a plan of enormous significance, my learned friend says, in the resolution of the original claim, and therefore in the resolution of the retrial. So it is that illustrates, these difficulties illustrate exactly why there must be a narrow approach to the focus of the fraud trial. Now, it's in that context that one looks at what Mr. Justice Leech said when he was considering the practical consequences. So there are two sources for this. The first is in his judgment refusing permission to appeal. That is in the core bundle not at the reference I've got. Give me one moment.
Well,
oh, it is. I'm so sorry. It's page 308 in the core bundle.
Yeah.
And paragraph 8 there. So he refers to Lord Justice Aikens in Highland that it must be shown that the fresh evidence would have entirely changed the way in which the first court approached and came to a decision. The only way in which I found it possible to apply this test was by evaluating the new evidence and then asking whether, in the light of that evidence, the judge's findings can stand. Any other approach seems to me to be unworkable.
But just to hark back, it doesn't actually, it's not what Highland says you should do. Not expressly.
Well, what he's saying is you have to evaluate the new evidence and then ask whether the judge's findings can stand. Any other approach would be unworkable.
Yes, indeed.
The second is back into our supplementary bundle, the slim white bundle. And it's at page 95.
Paragraph.
There are no paragraphs, so it's page 95.
So I thought you were going to the judgment of Leech.
No, this is now, it's in the supplementary bundle.
Oh, I see, back to your supplement.
What was said in the course of submissions leading to that judgment.
Yeah, okay.
And it's page 95,
Yes.
just after letter G.
Submissions.
This is in the course of submissions. Mr. Justice Leech says this: what I was doing, and this is really the point I want to put to you, what I was doing was really tracking my way through your pleaded case, dealing with the allegations as they were set out in the amended particulars of claim. And the more I sat and listened to the trial, and the more I wrote the judgment, the more convinced I was that any other way of dealing with it was almost impossible for a judge to do, because you were inevitably going to have to retry almost everything that the first judge had done, or perhaps the first half of the issues which he had to try, because you were focusing on the earlier period. And that was evidence which Mr. Tinkler and his witnesses had not given evidence to me in relation to any of those matters, although Mr. Tinkler was briefly cross-examined, I think, about the 24th and 25th of January. But in terms of a trial, that was a retrial of those particular issues, what I became convinced was that it was almost impossible for a judge to actually do the exercise that you're asking me to do, because you would have to, in effect, retry the whole action. So that's highlighting the difficulties that he considered that he faced practically as he went through the trial and then as he wrote the judgment.
Sorry, you're about to move on to...
I was, so...
Okay, so picking up the question that I put earlier, Mr. Wardell said, no, you don't retry all the issues. You retry the relevant issues. That extract gives us some hint of the problem, which is, what do you mean relevant issues? Because how do you ring fence the issues from the earlier trial, which you need to retry, as opposed to, I think, what you say, which is, no, look at the pleaded case on deceit.
Yes.
And try the pleaded case on deceit as pleaded, which in a sense is what Mr. Justice Leech comes back to protesting that he's done, in fact, in that exchange.
And forgive me for not addressing it. I meant to return to it. It is identifying what are the issues, and the issues are, the relevant issues are the pleaded issues. What is the new evidence, and so forth. That is the approach that Mr. Justice Leech adopts. I tracked through your pleaded case. It is evident that that's exactly what he does do. What my learned friend is saying is, well, I can come up with some sort of headline theory and abstract that and say that is the issue, and it is the same as the issue that was decided by Mr. Justice Brusson. It is not a complete retrial, because I'm not asking you to revisit the later stages of what might have happened at the AGM or the run-up to the AGM. But in terms of whether or not from January and February onwards there was a plan, yes, I can have a complete retrial of that issue. But the difficulty with that is that, as I think Mr. Justice Leech recognises, there are two difficulties. Firstly, he didn't have all of the evidence in relation to that, and felt strongly that he didn't, having heard what he did here. And secondly, that obviously conclusions as to what was motivating people in January and what their belief and understanding was as to different people's perceptions, what had been said to them and so forth, feeds into findings later on in the judgment by His Honour Judge Russon, findings that he makes about what was causing people to act in a certain way later on in the scheme of events. So it's very difficult to abstract that there are sort of what are the relevant issues, other than by doing it by reference to the pleadings and the fraud.
So, going back to Takar for a moment and what Lord Sumption said, I mean, Mr. Wardell says, look, it's a separate cause of action. The application to set, a cause of action to set aside something on the grounds of fraud. Therefore, you cannot rely on anything in the earlier claim that's been decided which might have been procured by fraud. That's the emphasis he places on it.
Yeah.
I think, as I understand you to say, no, what Lord Sumption is actually saying is it's a separate and independent cause of action. So try the new cause of action. Try the claim in fraud. Don't get sidetracked into partially trying on different evidence the first action, because that'll just cause enormous problems.
That's exactly right.
Both for yourself and will generate a second set of factual findings on issues which are the same as those in the first claim, and if you do decide to set aside the claim for fraud, the third judge won't know, as it were, what the status of those determinations are, if that's what you've chosen to do.
That's it.
Have I summarised your...
Absolutely, and better than I ever could. But so I not only accept that it's a separate cause of action, I rely upon the fact that it is a separate cause of action. And what Lord Sumption says is it relates to the conduct of the earlier proceedings and not to the underlying dispute. That's what the cause of action is about. So he's completely clear. That's paragraph 61 of his judgment.
And what was the relief claimed in the particulars of claim?
In the fraud...
In the particulars of claim in the fraud action?
Yeah, it was to set aside the judgment.
Just?
So it's at page 400 in the core bundle. An order setting aside the judgment for fraud and then restitution of the sums that have been paid pursuant to it.
Right, so it's just a claim that the judgment was vitiated by fraud and should be set aside.
Exactly.
And in those circumstances, presumably there would be directions for a retrial.
Yes.
And all the issues that were decided at the first trial would be decided again at the second trial once the judgment had been set aside.
Yes.
But you said the danger is if the approach at the fraud trial is to retry the issues in the first trial,
Then
you've
you're
got
binding the
you've got an issue with estoppel
binding
because they were necessary to decide to get to that conclusion, binding us between the parties.
Yes. So it isn't a retrial in a sense. It's not a completely open retrial as you would imagine. You would hear all of the evidence and be unfettered by any earlier findings, which is that the point of this is would be to get rid of, vitiate, any of the findings made by His Honour Judge Russon, so that the new judge had completely free rein with the full range of the evidence. But what my learned friend is saying is, well, actually, you're going to have findings. I'm not sure what he says happens to those findings, but you are going to have findings on at least some of the issues from the original claim having been determined by the fraud trial judge.
But is that a risk that arises simply out of the fact that there are in some cases, and were in this case, some overlap between the relevant issues in the fraud claim and the original claim?
What the fraud trial judge on my analysis should be doing is reaching a view on whether certain specific, the new evidence, so that which wasn't before His Honour Judge Russon, had been withheld, or perjured evidence had been given.
Well, perjured evidence given. So,
yeah.
in the circumstances of the plan, suppose that Mr. Justice Leech had been satisfied that the new evidence showed that there had been a plan, and that as a result, the evidence which those witnesses had given was perjured evidence, and that it was dishonestly so,
Yeah.
and that it was material. The relief that he would grant would have been setting aside His Honour Judge Russon's judgment, but there would be in existence a judgment deciding the issue of whether there was a plan, would there not?
It would be deciding the issue that these documents, the new evidence, as had been pleaded, demonstrated that there was a plan. So it would be open to the losing party on the fraud trial to go back and say, you have to look at the full panoply of the evidence, which the fraud trial judge didn't have, and you have to reach your own findings. They don't in any sense bind you.
I see.
But actually, it should be simply that they demonstrated that fraudulent evidence was given to the judge,
exactly.
which was material to his decision.
And inevitably, a party facing those findings is not going to relish going in front of a new trial judge and
I
a key witness is being told, well, you've been found to have perjured yourself. Well, that's a fact of the case, but they can go back and they would be saying...
But I understand. I mean, the finding that fraudulent evidence was given to the first judge would, on these particular facts, encompass a finding that there was a plan, but you say there wouldn't be any issue estoppel because it would would be confined to, that is what I find
That is
is
what I
the
find
effect of the new
of the
evidence,
new
not
evidence.
on the basis of a full trial of that issue as such.
Exactly right.
The focus is on the fraud that was perpetrated upon the court in the Russon proceedings. Now,
That's exactly what Lord Sumption says it is about. Exactly.
I'm not foreclosing debate on this, but it is 1 o'clock, and I take it you are on track to finish comfortably before probably 3:30.
Yes, what I was going to do is review over the short adjournment what I was going to say, because actually in the last two sections I think we've probably
You've said a
covered
lot of it already.
Exactly.
Well, we will resume at 2 o'clock.